This is an interview with Mr. J.S. Mullen, Ardmore, Oklahoma, March 10th, 1956. This is in Mr. Mullen's home at 18 D Street, Southwest. Mr. Mullen, can you tell us when you came to Oklahoma and why and where you were born?
I was born in Choctaw County, Mississippi in 1878. And I came to Ardmore from Nashville, Tennessee, where I'd won a scholarship from Arkansas. I came by way of Arkansas. When having won a scholarship by competitive examination, then I came on west with my father, who was a lawyer. And we located Van Buren and later at Fort Smith across the river. We went to Fort Smith because it was a seat of the largest criminal court in the United States, presided over by the famous Judge Isaac C. Parker.
When did you come to Oklahoma? What year?
16th day of June, 1898.
1898. Where did you settle?
At Ardmore. First settled here at Ardmore.
Settled here at Ardmore. What profession did you choose?
I chose the law.
The law. Can you tell us how you became a lawyer in those days?
Yes, you went to college, accredited school, and then you studied at home. You could be somewhat of a self-made lawyer, which is perhaps the best education after all.
Approximately how long did it take you to acquire this self-made education?
About 2 years.
About 2 years. Mr. Mullen, were there very many lawyers when you became a lawyer back then?
About 25 here in Ardmore. Ardmore has always been known for having a very strong bar.
Approximately where were your offices located then?
What is now, it's on the corner of Main Street and North Washington.
Where the city drugstore is.
What's that?
Where the city drugstore is now.
Yeah. Where the city drugstore now is downstairs. Approximately
how many rooms did you have then in your law office?
Well, it was more of a land office than it was a law office. Because I went into the land business. And of course, I had no titles and had to clear titles. There were two distinct areas. The titles that were all faulty. There were titles all clear, and clear with a twilight zone, which had not yet been discovered or determined. And it was that branch that all that I interested myself, because no country can prosper without having good land titles. That's good, isn't it?
Mr. Mullen, can you tell us why so many of these land titles were mixed up and confused?
Because they had to be construed, the state laws and the federal laws, all making treaties with the Indians. There were 54 treaties and with the Indians. Among the Choctaws and Chickasaws, with which we were mostly concerned, was the fact that there are two ways to make law. One is a statute already existing, which is plain. And then there's another way of construing that statute in such a way as to make court decision law.
Can you tell us something about your most famous legal battle about the land titles?
I suspect a famous case of Mullen versus Eves, in which a very dear friend of mine by the name of Jim Eves, a farmer here, and I made a contract in which to set him some land. He said the title to that land was faulty. And then I brought a suit against him. The case is to be found in the 107th Pacific. It's the most quoted probate case in the history of Oklahoma jurisprudence.
Where were trials of this nature carried on?
In the state courts. There was a building about where the Elks Lodge is now, North Washington Street, called the King's Building. The federal court is held on about where just across the street from, let's cut that out just a bit. The Federal Building was located in upstairs, just west of where Collier Brothers furniture store now is.
Mr. Mullen, can you contrast the law and order of today with the law and order of yesterday?
Naturally, being a new country and things were not settled, we were subjected to a great deal of crime. There were gangs and groups that would form and violate the law, and we do the best we could to curb those disorders. But some of us feared for our lives because of the retribution.
What the gangs did?
The gangs would knock you in the head and rob you, get drunk, and abuse you, as you threatened to reprisal or assert your rights, where they would further threaten you. There's a place called the Dewdrop Inn that is famous for that place, located on Caddo Street. Caddo today, as then, is somewhat famous for its dives and low places.
Can you descant for at length about the
philosophy of the law?
The philosophy of the law.
In that connection, it's very, very interesting. Law is complicated and complex, and I have mine here in front of me, excerpts from a book entitled "Growth of the Law." It was written by Mr. Justice Benjamin N. Cardozo, Chief Justice of the New York Court of Appeals, and later a member of the Supreme Court of the United States, had been appointed by President Hoover in his first administration. These excerpts are from the lectures of the Yale Law School in 1924. Now, I just cut that off. Now,
what else do you have to say, Mr. Mullen, about the philosophy of the law?
Well, carrying into effect the philosophy of the law as announced by Mr. Justice Benjamin N. Cardozo, he says this: a legal duty, so-called, is nothing but a prediction that if a man does or omits certain things, that he will be made to suffer in this way or that way by judgment of a competent court. The more I advance in age, says the Judge Cardozo, and seek to penetrate the problem of the law, the more am I convinced that law is not the creation of the state, that it exists without the state, that the notion of law is altogether independent of the state, and that the rule of law imposes itself on the state as it does upon the individual. Legal obligation is purely social, and is of such a nature that if it is not satisfied, it produces a disturbance of equilibrium, and in the constituent elements of the social group, resulting in spontaneous efforts to reestablish equilibrium. But courts are not much concerned with this phase of morals. The courts are creatures of the state and its power, and they therefore must obey the laws of their creators. It becomes a duty of the individual and the group composing the state to organize a reaction within reason and right and justice, composable to custom within the society affected. He further says, a constructive rule is a rule established to assure enforcement of a rule already established within the recognized existence of a state. They are obligatory both upon the state and its government, and upon the units that composing it. A judgment of a court is a process of discovery and not of creation. There is nothing to create by court. It is a duty to discover the purposes and intents of the makers of the law. The law-making body, a process of trial and error, brings judgment into being, and it determines the right to produce their kind in the future. Lawmakers are not omniscient. Indeed, sometimes they are lax. When a court is compelled to discharge of its duty to construe the great bulk of the cases more or less plain in the mind of the discriminating judge. But we sometimes come to a fork in the road, in which the philosophy of the law is so nicely balanced that a court in all conscience and reason may take either fork. The judge who finally chooses to believe with varying intensity of conviction that he showed well and wisely. Is there any more now? The conscientious lawmaker tries to make their enactment universal in their application. But the real lawsuit is concerned with particulars. Life has relations, incapable of division into inflexible compartments. The molds expand and they shrink. There is no such thing as a general received definition of philosophy. Descriptions must serve where definitions would be hazardous. The philosophers themselves fail us. The brilliant Roscoe Pound, Dean of Harvard Law School, in my judgment, is the most brilliant book ever written on the subject, Introduction to the Philosophy of Law. Here we find a philosophy of the origin and the aim of law. He accepts one set of arguments, modifies another, rejects a third. He drives both the judge and the practitioner forward or drives him back. To understand the law is back to fundamentals, to Plato, to Aristotle, to Aquinas, to Blackstone. Even among these masters there is war. They're at one another's throats.
Can you tell us your philosophy of the land cases back in the early days?
No country can prosper unless we have clear land titles, because sooner or later, all our living must come out of the land. Our fortunes rise and fall with land titles. It is for that reason, and being such a large landowner myself, that I was induced to go in and take the side of law and order and insisting upon clear titles in order that we might prosper and succeed.
How did you feel about when these cases came into court?
Of course, I naturally thought that I was right about it. But if I was wrong, why, I took my medicine the same as anybody else takes it. They should take it. Let's have law and order.